You may say that at some lecture, some point, he may have discussed or did discuss Florida Stand Your Ground issues. But again, without any particular relevance, the overall objection to these, again, being that it's sort of a 403. If there's no relevance, then the suggested relevance would be far outweighed by any prejudice, because I do not think that the jury should properly consider my client's past and his knowledge and what he may have known and what he studied. Again, for the issue that I mentioned earlier, that I think we're going down a very dangerous path for history. The last one is 201, which I believe is a same excerpt from another book for another class, for another professor, and that seems to be identified. I look at page 196, which is one page on psychological or criminal profiling and geographical profiling. It's actually one page?
It is one because the remainder of the next page talked about racial profiling, and I deliberately left that out.
So again, same relevance argument, unless the state can present that my client had this book, got this book, read this book, interacted with the professor about this book. I think it's purely speculative and would be dangerous for the jury to be asked to consider such evidence for whatever purpose, unless it's properly proffered to you, not only as to the theory of the case and how this would be relevant to that.
So your objection to 201 is relevance? Okay, thank you. Response?
And of course, 403.
Those were the 5 exhibits. So on Exhibit 212, your 212, 209, 210, 201, and I guess to some extent 211 are all relevancy. 211 is also authentication. 209 is distance and time, and those are the objections. State respond.
And also, of course, we would want a Richardson inquiry. We did receive these on June 21st in the middle of trial. So as to that.
Well, are those documents that were in the possession of your client?
No. No.
His handwritten homework assignments,
Absolutely
his application?
Not. Absolutely
Well, they're his documents. He knew of them.
I'm sorry?
They're his documents. He knew of them. He wrote
sure.
the applications. He wrote the homework assignments.
And I'm certain that he wrote Valentine's in first grade, but he didn't keep them.
Okay. Let's stay on point. Mr. Manti,
Let me
response?
address just a couple matters first. As Exhibit 201 goes, there is not just the profiling excerpt. There are also chapters on preparing for and presenting cases in court, strategies for excelling as a witness, and testifying under cross-examination. That is all as it relates to Exhibit 201. And I want to make sure that I'm also being clear that Exhibit, I believe it's 210, yes, contains not 2, but I think there are 3 homework assignments. The other one being a description of why the defendant is electing to take the course in the first place. I would also note as to 210 that at Mr. O'Mara's request, I have appended the entire course book to proposed Exhibit 210, although I had not originally done so. I don't know that they want that to be part of, if it is admitted, if they still want that to be part of it, but it is there for that reason. Let me start with the idea that we are here on a basic relevance objection. In order to be relevant, the state's, there are more than one theory of this case. There doesn't have to be married to only one theory. There are a number of matters which can be relevant for the jury's consideration, and the state isn't bound to only consider one possible thing or one possible theory. So to say that the state must, for some reason, tie things to a specific matter overstates what the actual law is as it relates to the concept of relevancy. In this case, the court has heard, and I believe will hear further, that part of the theory here is that the defendant's ambitions and frustrations are part of what's going on here. You don't get to consider each one of these things in a little vacuum. We sort of plowed some of this ground the last time we had this type of argument as it relates to his prior phone calls to the non-emergency number, beginning with his creation of the Neighborhood Watch program and for the 6 months thereafter between that and the shooting. I'm going to give a few examples of what we've already heard as far as this trial is. Neighborhood Watch training, his argument that this shows care of the community versus a counter-argument that it could be seen as simply him wanting to play police. He has had a desire to be an actual police officer, and I will point out that Mr. O'Mara has on a number of occasions and so has Mr. West, cross-examined various people, including Officer Tony Raimondo, about when they decided to become a police officer, why they decided to become a police officer, what they had to do that, and their motivations, and the fact that police officer is, in fact, a noble calling, a good thing. So I think they've already sort of made the idea about becoming a police officer and how strongly that motivates people and that sort of thing relevant by their own questioning. I think the fact of the college coursework is these are courses the defendant elected to take in pursuance of his legal studies criminal justice degree. The relevance of the application for the degree is that he submitted that application in the fall of 2011, and it indicates on its face that he wanted the degree to be conferred after he finished taking more courses in the spring term of 2012. The spring term of 2012. His coursework, at least some of these, already has focused on criminal justice and police issues. His extracurricular life sort of mirrored that interest, that desire that he has stated in a number of forums. The Neighborhood Watch, the Parking Committee, the calls and reports, and again, despite his vigilance in the community, what resulted in the arrest of a burglar in that community was the Stucco Man. He profiles and does follow, and profiling used in the sense that it is a investigatory type tool. He speaks, especially in his written statement so far, in written police jargon. And he tells Officer Serino, well, you have justifiable use of force or homicide. He indicates that. And he also, in that the written statement he made for the police, he uses such phrases as, I unholstered my firearm, not I pulled my gun. So the idea that we haven't already heard things about this to make this prior history and prior training as to why these sorts of things are out there is indeed relevant. And I'm going to talk about general relevance, but I want to go through some of the things that we've already heard in this case as to why these things are relevant. And then we heard the cross-examination of Detective Serino, where we had umpteen mentions of this is a police tactic. I think whether the defendant would have knowledge of it or knowledge of the law itself was brought up. As I said, part of the video that was played for the court, he referenced self-defense or justifiable homicide versus homicide. I think Mr. O'Mara actually said, I'm not trying to discuss trade secrets, but that's the phrase he used. So anytime we're talking about the defendant and tactics being used upon him, I think his knowledge that they were in fact tactics or potentially tactics, and his ability to understand the context of A, criminal investigation, and B, criminal litigation, and those are the titles of the two courses in question, is certainly relevant. I'm going to point out that jury instruction 7.4, this goes back to my point about nothing exists in a vacuum, is an act as a series of related actions. Its relevance shows why the defendant took a particular series of steps, exhibited certain behavior or attitude. 90.401 and 402 define the burden of relevance. It's anything tending to prove or disprove any material fact. It doesn't have to be a specific notion of or theory. It doesn't have to be, it can be. Anything that's material fact. Also, relevance has been defined as a tendency, and here I'm going to go into the cop show case, which is the first case in the stack that I provided to the court and counsel. Render a proposition and issue more or less probable. To be probable, the evidence gets viewed in the light of logic, experience, and accepted assumptions concerning human behavior. In the cop show case, the defense argued a state of emotional distress, which led to the killing. Therefore, they have placed the defendant's emotional state in issue, said the court. And in this case, the evidence in question was an affair that the defendant, cop show, was having. I'm sorry, that's KOPSHO.
Thank you.
It's 84 Southern 3rd 204, and I'm going to put the site up on the screen in just a moment. And the record here supported, and the court approved and admitted that the evidence of this affair was probative of the emotional state and the credibility of the defendant. I will also point out that on page 8 of that opinion, at the very top, the court discusses that this was put in issue by the defense's second-degree murder theory, and the state also argued that the evidence was relevant to impeach cop show's videotaped statement. So we have a number of purposes for which this is relevant. This isn't impeachment about something merely collateral. It is simply a fact that the jury ought to know. When they hear one assertion on videotape, they deserve to hear the rest of the story. Relevance can pertain to any of the elements of the crime. The defendant's state of mind here, the ill will, the spite, is an element of the crime. That is documented in the Wimberly and Hart cases, which are the next two cases in the stack that I provided the court. Relevance can pertain to any element of any defense. The state also in this case has the burden to establish that this is not a self-defense case, and that includes whether the defendant might have provoked the incidents, or to use the phrase in the Billode case, which is 578 Southern 2nd 343, that's Billeaud as indicated on the screen. The theory in that case, and I'm reading from the bottom of page 2, tended to prove a material fact central to the appellant's, in this case it was the defendant wanting to introduce this, that it was the straw that broke the camel's back. This particular camel, if we stick with that metaphor, has been carrying an ambition or a desire to be a police officer and to act in certain ways and behave in certain ways, and I think that's relevant to explain his behavior on the night in question, or at least assist the jury in having a fuller depiction. As far as being relevant to theory of the case, it can show the context of the defendant's behavior. This is a segue into the Holmes case, which we discussed pretty extensively before, which is 91 Southern 3rd 859. It's the next case in the stack. Continuing chain of, and I'm reading from page 3, continuing chain of chronological events, and even though it was prejudicial, almost all evidence introduced by the state is prejudicial to the defense. Credibility is at the heart of the case, and it prevents the state from fairly and adequately making the case against the appellant if the evidence is excluded. In that case, it was evidence of drug dealing. Morjon is a similar thing, and that can be found on 394 Southern 2nd 1100. Also on page 2, and also, again, evidence of even actually other not-so-good activities. The state isn't asserting that these are bad acts. The state is simply asserting that these are acts by the defendant and things that he has elected to do which are relevant to help the jury understand his actions on the night in question. Continuing on the point about theory of the case, in the Samuels case, which is 11 Southern 3rd 413, the next case in the stack, and I'm going to read, I think, beginning on page 3 at the bottom, starting around headnote 8. The court in that case admitted a couple different things. First, they admitted evidence that the defendant hid assets in the Cayman Islands in other people's names, and that was relevant to the state's theory of the case. In that case, the state was proceeding on the theory that the defendant committed murder because he didn't want to have to pay child support, and he was hiding assets to do that. Second thing the court admitted was documents from the child custody case that were relevant to the state's theory that the shootings were the culmination, in that case, of an ongoing battle. Again, we're back to the sort of straw that broke the camel's back type scenario. And that citation, again, is 11 Southern 3rd 413, Samuels. Familiarity, and we may hear this again as it relates to other evidence, but evidence that shows familiarity with or proficiency in certain tactics. In the Marquard case, that's Marquard versus state, it was martial arts and military tactics. But familiarity with tactics, police tactics in this case, is not by itself evidence of bad character, nor is it similar fact evidence of another crime. It's just relevant evidence. Familiarity, in fact, can be a valid reason for a lot of things that wouldn't ordinarily necessarily be admissible. And this is the Rhodes case, which should be the next one in the case, and I'm reading page 9 of 11 of the court's copy, 638 Southern 2nd 920. In that case, the court held that evidence of actually the defendant in that case being familiar with police procedures because he'd been arrested before several times was familiar, and in that case, to show that he'd voluntarily waived his Miranda rights. So the idea that someone is familiar with police procedures is not an unheard of or uncommon concept in the history of the law, and it's not something that's necessarily inadmissible for any reason. In fact, it's been admissible for, I would submit, far more significant and serious reasons. You're talking about now here supporting the idea of whether somebody waived their Miranda rights. Moving on from theory of the case for a moment, if it is relevant to other facts in issue in a case, any fact in issue, the defendant's motive, defendant's state of mind as to whether he's profiling or not, according, again, referring to the Hart case, those are classic jury issues. Defendant in his opening statement portrayed himself as simply a concerned neighborhood individual, and there's a question about whether he was concerned or exhibited hostility. Did he observe or did he profile? The impact, and I'm going to move on to the next case in the stack, which should be Eugene versus State, which is 53 Southern 3rd 1104, and I'm reading from page 4 of that opinion. In that case, the evidence in question, and they were statements and emails that the defendant received, showed they were relevant to show the sudden deterioration of his relationship with the victim, demonstrate their impact on the appellant. And so it's the impact of these prior things that have gone on in his life that can be a fact in issue and is relevant. Other facts in issue. There was ample implication during cross-examination of these witnesses that he only followed Trayvon Martin, that the defendant only followed Trayvon Martin. And this is in the cross-examination of Mr. Nofke, that there was some kind of supposed suggestion in how he interpreted the words. I think the testimony of even Mr. Osterman yesterday sort of indicated, well, I think maybe he just interpreted it some way, but here's what he said. So actually, whether or not the defendant knows better or would have any reason to know better is relevant. Cross-examination, again, Mr. Romero's cross-examination of Detective Serino about the trade secrets sort of thing. The statements in the interview, especially his written statement. The idea that he has been exposed to materials on and taken a course that covered how to be a good witness. And this is all, again, the coursework intertwined with the other evidence of his ambition and his activity. And not that there's anything wrong with that ambition, but it certainly goes to the defendant's state of mind. He has applied to be a police officer before. He still wants to be one, according to some of his homework assignments. The homework assignments are relevant because that's the sort of thing that he did in the class he was involved. This isn't sort of some passive non-thing, especially the one that tells you why he wants to take in the class in the first place. The idea that he wants to go ride along with police, that he wants to be an affirmative participant in what's going on. Again, not that it's bad, but it's relevant. I will also point out that there is a relevance as to the defendant's particular knowledge. The state argued in a case as part of its identification theory, and I'm now on to the Williamson case, which I think is the next one, that the evidence demonstrated in that the gunman had knowledge of legal forms. The killer in that case had legal forms. And as proof, the state sought to submit that the defendant had actually filled out and knew how to fill out other legal forms. And the court held that that was admissible, relevant to the issue of, in that case, the identity. And they agreed that the introduction was not 90.403 material. And I will point out, I want to address 403 for just a moment. Rule 403 says the danger of unfair prejudice must substantially outweigh any probative value. I have yet to hear how any of these documents are supposedly prejudicial, let alone unfairly prejudicial to the defendant to that kind of degree. They have asserted none. They are clearly probative of his experience, his desires, his state of mind as of the time of this killing. And so, Your Honor, as it relates to each exhibit in particular, State's Exhibit 209, which is simply the fact that he had completed enough coursework to be applying for a degree at the very term that he would have been completing when this homicide occurred. Two of the particular courses he took, criminal investigation and criminal litigation, which bear in a number of ways on his behavior in this particular incident, as well as his behavior in other contexts, and the fact that he would know, and there's nothing secret about this, the idea is that if he were ever involved in this kind of situation, he would know what there might be asked of him, done with certain pieces of evidence, what he might be asked about, the type of questions or the way that they might be asked. He would know these things, or at least would have reason to know these things. Again, as it relates to the prior application for the police force, as well as the application to ride along with the Sanford police force, it shows his continuing involvement, and this is over a period of time. This is not some Johnny-come-lately to this idea. This is a person who has decided that he wants to not only do this, but he wants to receive a degree in it. And there's nothing wrong with any of that, but it certainly tells us a little bit about the defendant's state of mind when he encountered this individual that he automatically, the first words out of his mouth were, a suspicious guy. So the state believes that all those 5 exhibits are relevant for not just one reason, but a number of them. None of them are conceivably more prejudicial than they are probative. And we've made efforts to redact the personal information so none of that would get out.
There's none of the bad credit or any type of good credit or any personal information that would...
The personal information we took I screened it first, I asked the defense to screen it too, and the clerk finished the job, and I think between us we pretty much have got everything. The thing that Mr. O'Mara referred to was a summary as to why the application was denied, which does cite COLL credit history. If that one...
That would need to be redacted.
I'm fine if the defense wants that. Again, if they want to avoid the implication that he was denied for any other reason, I understand that as well. So it is there, but I have no objection if that particular part of it gets redacted. And as far as the authentication of it, it is the letter actually, the research was done.
Just for the record, that's part of 209. No,
I'm
that's
sorry,
part of 211.
It's part of 211, Your Honor. The letter in question and the research was done by Lieutenant Scott Kerns of the Prince William, Virginia Police, and he is the witness who would be testifying about it. They do not keep the full application for any more than their statutory required period, and so the record as to the application doesn't exist, but the record that he applied and was rejected does, because Lieutenant Kerns wrote the letter. As far as whether the defendant had to, I want to address the argument that he somehow we have to establish that he particularly knew about or was present in a certain class when a certain subject came up. I believe, again, that overstates the idea of relevance. The idea of relevance is that the defendant expressed an interest in this type of course. He paid for it. He took it. He was seeking a degree in it. And the notion that a college guy never misses a class, and one of them was even an online course where you'd have to interact in a chat board forum and things of that nature. The idea that you have to establish that he read a particular word in a book, I think, again, way overstates the idea of relevance here. The fact is he sought out and then, of course, had access to and was obliged to get a grade about, and he got an A in litigation, I think a B in investigation. That he had to do all those things and that these were his choices. So I don't think the state has to necessarily prove that the professor put eyeballs on him and had him sitting in the seat in order to make his choice of course and the material that would be covered in that course relevant to the state's theory of the case.
Thank you. Mr. O'Mara?
First of all, of course, they're calling this witness for some type of impeachment, but beyond that, Your Honor, having just been given 10 or 12 cases from the state, I would ask for a couple of hours to actually,
Sir, I gave you all night last night and a half hour yesterday, and I told both sides I understood your arguments, and I needed you to be prepared to come with the case law to support your arguments. So
may I finish my request? May I finish my request? So
may
that it's
I
on the
finish?
record?
I will let you finish, of course. The purpose of having this argument this morning at 8:30 was to give both sides the opportunity to provide to the court case law that would support their position. I have a jury sitting back there. This issue, I spent the night looking at it. Both parties spent the night looking at it. Let me hear your argument.
My request is for a continuance for a couple of hours because I've just been given about a dozen cases from the state that seem somewhat instructive to the court, but I've noticed already, just as Williamson and other cases, just in the moment I've looked at it here, that there are distinguished characteristics to those cases that I need to have an opportunity to present to the court. So, to the extent the court is going to rely at all on the state's argument and the case law that I have not had a chance to review, then I would ask for some time to do that on my client's behalf.
Well, again, Mr. O'Mara, in all due respect, we started this issue yesterday afternoon. I had the jury out for a half hour so you could have time to research this issue. You came back and told me that you needed overnight because it wasn't enough time. Recessed early yesterday, provided counsel for both sides overnight to research this issue, and I will listen to any cases that you have to support your position, but I'm not continuing this matter.
With that in mind, Your Honor, the state's cases to date seem to show, first of all, I would think that it is in fact a 404-2 argument, because if in fact they are trying to bring in acts that they are then going to argue the relevancy to the jury, then they are in fact 404 attack on my client's credibility, and they can't slide past their requirement to give us notice of these prior acts 10 days before trial by suggesting, well, that they're not really bad acts. We're just going to argue that they're bad acts. Well, actually what they're going to argue is that they suggest, as the state has now acknowledged, that these acts somehow support their theory of defense for second-degree murder. So they can say to you that they're not really bad acts because they don't want to have a 404-2 analysis of it, but that's exactly why they're putting them in. They are putting them in so they can turn them into seething bad acts, subtle but seething bad acts of my client. So they can't color it one way to bypass 404-2 and then color it another way in their argument to the jury. If, in fact, they are going to argue to this jury that these are evidence of knowledge, of forethought, of knowledge which was the foundation for his ill will and hatred, that he had this available, then it is, in fact, a 404-2 analysis. They violated their requirement under the rule to give us 10 days' notice ahead of time. That then demands a Richardson inquiry as to that issue. So in that sense, they can argue to you that it's not 404-2, but it, in fact, is. And let's look at why. The case law that they have suggested to you to date, today, is all, in effect, prior bad acts under 404-2. An affair to show anger and hostility towards a person, the wife, ex-wife, he ended up killing. Hiding money in the Cayman Islands to avoid child support. A bad act to show what he was doing to presume the ongoing battle between the two. The sudden deterioration of the relationship between the defendant and the alleged victim. Again, the bad act information, 404-2. What they're saying is, well, it doesn't look bad on its surface, Judge, so ignore 404, but we're going to argue that it's bad. We're going to argue that he was a seething cop wannabe and argue that to the jury. They can't slide, I would suggest to the court, they can't slide by the evidence code and suggest to you that this isn't exactly what they're going to do. So I would ask again that they somehow relate this to some theory of the case factually. What does the state say happened on the night of February 26th that makes this information relevant to prove a fact? Do they say that he ran after him? Do they say that he tracked him down? There's no evidence to support that, not to date, certainly, and I don't think that they're going to be presenting any more factual evidence in that regard. So in effect, what they're doing is trying to subtly present evidence through you, through this argument and your ruling, that they will then turn into 404B evidence to the court, and that's not allowable, which is why we have 403, to look at it and say what it is that they're trying to do and what purpose is. So if, in fact, they're going to bring in prior good acts of my client, which they can't do either, by the way, unless they show a connectivity, a relevance to some theory of their case, and I would again ask that they proffer both the theory and further they proffer the actual evidence, because it is still my position that if, in fact, they're going to say my client knew of stand your ground, and that's somehow impeachment, again, on, I believe, a collateral issue, an improper impeachment, But if they're going to say that as a foundation bringing in this evidence, then at least they should proffer it to you for you to make a primary or threshold determination that this is in fact relevant evidence, that he was in the class, that he did know about it. What they're doing, and I was only half kidding when I said Valentine's in first grade. There's an enormous amount of information that we carry on with us as adults. But we're not held to know it completely and fully in a criminal courtroom in a second-degree murder case unless you can connect those dots, unless you can say without question, yes. In all of the cases, including Williamson, that I just had a chance to look at, the court looked at it and said, as to that particular issue, where they connected up, this form he filled out is very relevant to this fact, and there is a connection, we will allow it. The problem here is that we do not have any connection. We do not have any from the state. We have great argument that their theory is he wants to be a cop. And somehow, the fact that he wants to be a cop and actually went to a class, we should be able to argue that he wants to be a cop. Well, if in fact they're going to limit themselves before you, that they're only going to argue he wants to be a cop, then it's not relevant. If in fact what they're going to try and argue is he's a seething cop wannabe, then they have to show that there's a connectivity between the two to make it relevant, and they failed to. And I renew my request for the profit of the evidence so we can see actually what these professors are going to say before a jury hears it, because if in fact it gets to the jury, we can unring that bell, and again request more additional, additional time to address this.
Okay, thank you very much. Did you have something further you wanted to say?
If I could, Your Honor, I just want to refer back to two cases, and that's Marquardt and Holmes, and I'll quote briefly from Marquardt. Evidence showing familiarity with or proficiency in tactics is not by itself evidence of bad character, nor is it similar fact evidence of another crime. In that case, again, that was the martial arts type tactics. So, and Holmes, of course, we covered very extensively when we covered, but this is inextricably intertwined evidence to various things. As far as proffering the evidence, well, I videotaped one of the professors and gave the defense that. As far as a Richardson inquiry goes, they've had certainly access to all the college materials and everything else. They've had the records custodian and his transcripts and everything else have been listed for months. In fact, the defense was so on notice of all this stuff that they filed a motion in limine before this court seeking to exclude any mention of the phrase wannabe cop or anything like that. So to now come in and say, oh, we're surprised by all of this, we have no idea, these people have been listed for a long time. The only exception to that, really, is the homework assignments that when I followed up with Professor Jackson, he provided, it was either a week or a week and a half ago, somewhere around that, and I provided them the day I got them. That's really the only thing that hasn't been, and I will point out, Professor Jackson's been listed for quite some time and has never been elected to be deposed. So I simply say that the effort here to now, and I'm glad I brought the picture along, is being, as we expected, to try to shoehorn this from 401, 402 to relevance to 403, more prejudicial and probative, to now we're at 404. And what that tells me is that the defense doesn't really know what the proper objection is because there isn't one.
Okay, thank you. I have reviewed the evidence code. I've reviewed case law, and after listening to the arguments by the counsel today, the court makes a determination that the testimony bears directly on an issue in this case. Therefore, testimony is substantive and the objections are overruled. Do you need a few minutes to get your first witness ready?
There was an issue regarding the redaction of the
credit
application.
As well as I just needed to know whether the course book still you want that included or not.
The concern with the redaction, Your Honor, is though it is distasteful to have that information before the jury, taking it out will simply allow speculation that there was some other reason why, rather than just the fact that he had bad credit. So in the Hobson's choice of having to allow the jury to know that my client had bad credit, which I think is completely inappropriate.
Does it say the words bad
Yes.
credit? What if we just took out bad and just put
Let me
credit?
add one other to this. The lieutenant will say that that is the reason that was listed, and that could mean one of two things. It could mean there was in fact a credit problem, and it could mean that the defendant was not candid about his credit reporting. Either one of those I don't think is an inference the defense wants drawn, but I'll defer to their wishes on that.
I'm in a Hobson's choice. I need to decide
Well,
between.
what if we took out the word bad and just put credit as an issue and left it there?
It says the same thing to the jury.
This
I
wouldn't
mean,
Could be they weren't able to verify the credit, doesn't mean it's bad or good or indifferent.
Actually, if they want to strike the whole last page of it, that's
Oh,
also
well.
fine.
There you go, then the last page will be stricken.
have a
Issue
moment to review it.
not an issue. They're figuring that out. We'll take a 10-minute recess. Court will be back in 10 minutes. Be seated. Court is in session. Okay, we ready to bring the jury in? Did you make the decision about the redaction for the exhibits?
Yes, we did.
And based upon knowing your objection to those exhibits, but based upon the court's ruling, are the exhibits in the order that you think are appropriate?
Yes, Your Honor.
Okay, thank you. Let's go ahead and bring the jury in.
I'm not asking you to rethink it. Are you letting in all the homework assignments as well, the whole?
All
shebang, so to
exhibits,
speak?
those are exhibits 212, 211, 209, 210, and 201, as agreed to be redacted.
What about that?
Okay. Let's go ahead and bring the jury in.
Yes, Your Honor.
Jury is present, Your Honor.
Please be seated. Good morning, ladies and gentlemen. I hope you had a good evening. Before we get started this morning, I'm going to ask my questions. If your answer is yes to any of the questions, please raise your hand. During the overnight recess, did any of you have any discussions amongst yourselves or with anybody else about the case? No hands are being raised. Did any of you read or listen to any radio, television, or newspaper reports about the case? No hands are being raised. Did any of you use an electronic device to get on the internet to do independent research about the case, people, places, things, or terminology? No hands are being raised. And finally, did any of you read or create any emails, text messages, Twitters, tweets, blogs, or social networking pages about the case? No hands are being raised. Thank you very much. State, you may call your next witness.
Thank you, Your Honor. State we call Sonja Boles-Melvin.
solemnly swear or affirm that the testimony you shall present will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Thank you.
You may proceed.
Thank you, Your Honor. Ma'am, please do me a favor. Spell your name for us and tell us who you are, where you work, and what you do.
Sure. My name is Sonja Boles-Melvin, and it's spelled Sonja Boles-Melvin, and I am the registrar for Seminole State College of Florida.
What is a registrar?
The registrar is responsible for all of the educational records, academic records of the institution.
And I assume that your institution keeps academic and institutional records.
Correct.
I'll show you what has been marked as State's Exhibit 209 for purposes of this proceeding. Do you recognize that document?
I do.
And is that the type of record that is ordinarily kept in the course of your institution's business?
Yes.
And does it pertain particularly to the defendant, in this case, George Zimmerman?
Yes.
Now, there are two sort of sections along with this, if I may, Your Honor. The first is what I'll call a grade change form. Do you see that?
I do.
Okay. And this was actually submitted for a particular course in a particular department. What is that department, ma'am?
It is legal studies,
Okay. And it is course of which title?
criminal litigation.
Okay. And the second is a diploma or certificate application, also in the name of the defendant. Can you tell me, is this something that, when would a person fill out a form like this?
When they are ready to be awarded a degree from Seminole State College.
So they fill this out to ask to apply for a degree?
Correct.
Right. And tell me when, A, when this form was filled out, and B, if you can tell, when the degree was actually supposedly going to be conferred or was being requested for.
Mm-hmm.
Okay, it looks like Mr. Zimmerman applied for graduation during the term of fall, which would have been our fall commencement. And he applied on October 17, 2011.
Okay, so that was when he submitted the application. Does it tell us when he was requesting or thought he would have the degree?
Yes, he thought he would graduate by spring 2012.
Okay. Thank you, ma'am. No other questions, Your Honor.
Thank you, Prof.
No, thank you very much.
May Ms. Boles-Melvin be excused?
Yes, Your Honor. Thank you.
Thank you very much, ma'am. You are excused.
And I would move at this time State's Exhibit 209 into evidence.
Based upon the court's ruling, it's submitted into evidence as State's Exhibit 209. Call your next witness, please.
Thank you, Your Honor. Lieutenant Scott Kerns.
Do you solemnly swear or affirm that the testimony you shall present will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you.
May proceed.
Thank you, Your Honor. Morning, sir.
Morning.
Would you please go ahead and spell your name for us? Tell us who you are, where you work, and what you do.
Lieutenant Scott Kerns, Prince William County Police. Last name spelled Kearns, first name Scott. I'm currently assigned to operations, Prince William County Police, Prince William County Police, and prior to that I was the bureau commander for the Prince William County Police Personnel Unit.
Okay. Prince William County where, sir?
In Virginia, sir.
Okay. And does the Prince William County Is there a particular name of that agency? Are you the city police, the county police? What?
It would be county police.
And does that agency normally keep records of people who apply for jobs in that agency?
Yes, sir.
Jobs, both civilian and as a police officer?
With the police department, yes, sir.
And in your capacity as the manager of the personnel unit, would you be the person who would normally be, I'll call a custodian of records of that type?
Yes, sir.
How long does the Prince William County Police Department keep the actual applications of records?
Well, in accordance with the Virginia Records Retention Act, what we do is we keep them for the mandated 3 years, and after which time it's standard practice for us to destroy the records after that period.
Were you asked to investigate whether you had any records as it relates to an application to become a police officer in Prince William County by the defendant, in this case, George Zimmerman?
Yes, sir.
Were you able to locate the actual application?
No, sir, it was destroyed.
I'm going to show you what's marked as State's Exhibit 211. And do you recognize this exhibit, sir?
Yes, sir.
Okay. What is that?
That's an extract of what we do is after we destroy, you're talking about this first document?
Go in.
Okay. After we destroy the records after the period of 3 years, we create a very cursory amount of information on the record that was to be destroyed. Basic information, name, address, date of applied, et cetera. And additionally, we also send out a letter for those individuals that are not considered further into the process. We send them a dated letter with my name at the bottom regarding their status, and then they're not going to be considered further.
Okay. And in this case, what was the date of that letter?
The date was July 8th, 2009.
Now, Lieutenant, I'd imagine you get a lot of people who apply.
Yes, sir.
Okay. So is there anything unusual or sinister about just people not getting the job as an officer?
No, sir.
Okay. Thank you. No other questions, Your Honor.
Thank you. Any applause?
And I would move at this time State's Exhibit 211 into evidence.
It'll be admitted. State's Exhibit 211.
Morning, Lieutenant Kerns.
Morning, sir.
Your position in the police department is because you're a sworn police officer and have full privileges as such?
That's correct, sir.
Are you currently serving in any kind of investigative capacity?
No, sir.
It's more administrative?
I just recently changed assignments just over 3 days ago. I'm now the watch commander for the Western District Evening Squad. But prior to that, I was with the Personnel Bureau.
So it's not uncommon, I take it, within a given police department to change hats from time to time?
No, sir.
Maybe patrol, maybe investigator, maybe behind the desk?
Yes, sir.
How long were you in the administrative position prior to your current assignment?
6 years, sir.
So you were the administrator then at the time Mr. Zimmerman applied?
Yes, sir.
Do you have any, you have no copy of his application, I take it?
No, sir. It was destroyed.
And you couldn't tell me, for example, who he used as a reference on his application?
No, sir.
You don't have a personal memory of the contents of the application itself?
No, sir.
Because, as Mr. Vanta said, you get a lot of them.
Yes, sir.
A lot of people want to be police officers,
Yes, sir.
as did you, obviously.
I did.
So, if I understand the process then, there is an application, obviously, and then under your records retention policy, after a period of time, the actual record is destroyed and there is a brief extract or excerpt from the application, or from the process, rather.
That's correct.
In this exhibit, which is marked as 211, you are certifying here that you are the records custodian.
Yes, sir.
And that what's attached to it is a business record.
Yes, sir.
I notice, for example, that it's not on letterhead and it's not signed, and it doesn't have any more information on the document other than the actual written contents of it.
That's correct, sir.
So this isn't a copy then of the actual letter that was sent in the mail?
It's not the actual copy that was destroyed. That's the document that was used to create the original in terms of later my signature was placed on it along with the letterhead.
This would have then basically been the word processing document that was printed?
Yes, sir.
And you don't have a specific memory of reviewing or signing this?
No, sir.
This is just one among other documents that are kept in the system?
Yes, sir.
And then this other page of the document, if you can see it well enough from here, just to help me know what it is this the extract you're talking about?
Yes, sir.
And in this extract, it includes, of course, Mr. Zimmerman's name and social security number and his address at the time. That would be the address at the time he filed the application?
Yes, sir.
It would indicate ethnicity.
Yes, sir.
It would indicate gender.
Yes, sir.
Is that what that means, G?
I'd have to, some of them were rather abbreviated and cryptic. Yes, sir. That's correct.
G would be gender, and then Mr. or would be Mr.
Right. Yes.
A guy.
Yes, sir.
Spanish,
That would be any languages spoken other than English.
so that it would indicate that Mr. Zimmerman's bilingual.
It would indicate that he stated that he knew another language other than English. In other words, we didn't confirm that, so this is all self-disclosed information on the application, and we just transpose it onto the spreadsheet. So we didn't validate anything in terms of his Spanish-speaking skills. That was self-disclosed.
I see. Well, as would be the birth date and the social and everything else. Right?
Well, some of those things can be confirmed up front through driver's licenses, et cetera, but Spanish would be an actual test that would be performed later in the process.
I see. Gotcha. And then at the end, there is a column that says COLL, comma, credit history.
Yes, sir.
Do you take that to mean that Mr. Zimmerman had a problem with his credit?
Yes, sir.
And that would be a reason why you wouldn't be accepted as a police officer?
That's the reason why we did not consider him further based on that record. Yes, sir.
It makes sense if you think about it, doesn't it? Because a police officer who has credit problems would be vulnerable to criminals, wouldn't they?
Possibly.
They could be put in compromising situations where they may make a bad decision because of their financial concern.
Yes, sir.
So if somebody has bad credit because of their age and not having a clear established work history or any number of other reasons that shows up as bad credit, he would be, in fact, was rejected.
Yes, sir.
So that would mean, I take it, that when his credit got better, or he was able to fully address that issue to the satisfaction of the department, he could reapply.
It's possible, sir.
In fact, you know of people that have applied once, been rejected, maybe applied again, even with other agencies, and ultimately gotten on.
Yes, sir.
May I have just a moment, Judge? Thank you. Thank you very much.
Yes, sir.
Thank you. Any redirect?
No, thank you, Your Honor. I ask you to be excused.
May Lieutenant Kerns be excused? You said yes?
Yes.
Yes, thank you very much. You are excused. Please call your next witness.
Captain Alexis Carter, Your Honor.
Do you solemnly swear or affirm that the testimony you shall present will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you.
You may proceed.
Thank you, Your Honor. Captain Carter, if you would, please introduce yourself to the jury. Tell them who you are, name, rank, serial number, where you are.
Roger that. Captain Alexis Francisco Carter, United States Army, assigned to 3rd Infantry Division, Fort Stewart, Georgia, United States Officer, JAG Corps.
Tell me what JAG Corps means.
Stands for Judge Advocate General. I'm basically a military prosecutor in the Army.
So you're yet another lawyer.
Yes.
Captain Carter, do you also teach courses?
I did at one point, but not currently.
Okay. Would that have included back in spring of 2010?
Yes, I taught a course, yes.
Where did you teach that course?
Seminole State College.
And what was the name of that course?
Criminal litigation.
Do you remember the defendant, George Zimmerman, being a student in that course?
I do.
Okay. And actually, do you remember what kind of grade you gave him?
I give him a name.
All right. Tell me a little bit about what type of course that was.
Well, when I got the book, or when I got wind of the course, criminal litigation, I automatically assumed that I'll be teaching it from a more practical standpoint, trial advocacy, things of that nature. But the way the course book was set up, it wasn't really like that. In the time frame in which I had to teach the course, I couldn't really teach it from a trial advocacy standpoint. So it was mostly like a crim law, crim procedure course. We talked about the law, elements of the law. We talked about criminal procedure, the constitutional rights, 4th and 5th Amendment, things of that nature.
Did you almost do any kind of what I'll call mock trial sort of thing?
Not really. Not in that course. We didn't have the time for it. Again, it just kind of focused on the elements of the crime, and we would go through hypotheticals where we would ask the students certain questions regarding certain cases and things of that nature.
You mentioned your course book.
Sure.
I'm showing you just what's... Is that your course book titled Criminal Law and Procedure?
Yes.
Okay. And I'm showing you what's in evidence now or been marked as State's Exhibit 210. Is this a sort of subsection, very small section of this very big book?
Yes.
Okay. And that's a chapter specifically pertaining to what?
Self-defense.
Okay. And the second part of State's Exhibit 210 is what?
It's a email homework assignment from George. It was the first homework assignment that I gave to all the students.
Okay. And is that the rest of it actually additional homework assignments?
Yes.
Your Honor, I'll move State's Exhibit 210 into evidence at this point.
Are you moving the book or the excerpt?
Just the excerpt and
Okay, they'll come in as a composite exhibit 210.
thank you, Your Honor. Talk to me a little bit, Professor, about what kind of student you remember the defendant to be.
As you always kind of remember your smartest student, or the one that stood out the most, the one that probably wasn't the best student, and he was probably one of the better students in the class.
You mentioned that, and we talked about State's Exhibit 210 as an excerpt from the book about self-defense. Obviously, you were teaching this course in Florida, so tell me what sort of things you addressed as it relates to the law of self-defense in Florida.
Right, so the way the book is comprised, obviously the publishers aren't from Florida, didn't really put Florida-specific things, but I wanted to teach the class from a practical standpoint where these students can really relate and take something from it and apply it to their own lives. With Florida and other states, they have what's called the Stand Your Ground law, which evolved from the Castle Doctrine through case law.
And did you cover that specifically?
Yes.
did you discuss specifically self-defense and stand your ground laws in the connection of violent crimes such as murder?
Yes.
And did you address the particularities of, strike that question, bad question. Professor Carter, what can you tell us about how long you spent as part of that course covering ideas like self-defense and standing?
Right. You know, self-defense is a affirmative defense. It's a big self-defense. It's not one of those things that you're going to just whisk through in a day, or after you teach it, you're going to neglect from bringing it back into the classroom. So it was something that I constantly iterated. I was the type of professor that before I gave any tests, I gave a review for the test. And it was something that I think the students really wanted to know about. It was so practical that they were very much engaged in class discussion regarding the issue. So I remember, talking about it, quite a few times, not just on one particular occasion.
Thank you, Professor. That's a tough question.
Okay, thank you. Cross?
Excuse me a second.
Sure.
Good morning, Mr. Carter.
Good morning.
My name is Don West. I'm one of the attorneys for Mr. Zimmerman. You see George over here?
How you doing, George?
And Mr. O'Meara is co-counsel on the case.
How you doing?
How long have you held your current position in JAG Corps?
October would be 3 years.
And you taught at Seminole State College, was it beginning the semester of January 2010?
Yeah, so it would have been from January 2010 timeframe to probably, I don't know, May.
Was it just the one term?
Yes, I only taught one class, and that was it.
Mm-hmm. And what did you do after that?
Right around that time, well, I was also working as a PD. I was at the public defender's office during that time, full-time as Orange County Ninth Circuit. So I went back to work, and I left for the JAG Corps for training October 2010. So I went back to work full-time to the PD's office, and then went off to the JAG Corps.
Were you working for the public defender's office in January of 2010 while you were also doing the adjunct professor?
Yes.
I got you. Okay. Do you remember when you started with the PD's office?
So that would probably be November 2009.
Was that shortly after you became admitted as an attorney?
Yes.
Admitted to the bar?
Yes.
So that was your first job?
It was.
As a lawyer, with the public defender's office?
It was.
And then you took on the responsibility of the class as kind of a side job?
Yeah, I hopefully one day I could be a law professor, and I like teaching. And the cool thing about that job, teaching, was that a lot of the things that I have to know or had to know every day for my job as a PD was reinforced by educating others.
So when you made the comment that your approach to the class was really from a practical standpoint, you were talking about how this stuff works in real life?
To the extent that you can. It's been said that there's law on the books and law in action. Anybody can tell you what a recipe is, but if you get in the kitchen and don't know what you're doing, you're going to mess up the recipe. So understanding the law and how it's applied, especially when you're dealing with crimes, is so different than anything else. Any fact or change in fact can change the outcome. So that's what I meant.
So even though there might be thousands of individual facts, it could be just one or two that may have significance?
Well, no, all facts have significance. You generally look at things from the totality of the circumstances, but there's certain things that, through case law have been seen to give more weight.
Sure. The totality of the circumstances is you look at the sum total of the evidence, I take it, and then also apply common sense.
Right. A reasonable person standard is what that's generally referred to.
In fact, interestingly, it's the reasonable person standard or the reasonable belief standard which squarely is part of self-defense.
Yes, you can say.
And we'll talk about that more in a minute, but the work that you're doing now,
Yes.
are you prosecuting or defending?
Prosecuting.
Just prosecuting?
Just prosecuting.
Do you have the opportunity to defend?
No, I do not right now in this position that I am, but the way the JAG Corps is set up, they put you in a certain position, and throughout your career, you move on to different things. Before being a military prosecutor, I dealt with administrative law, federal regulations, interpreting of regulations, giving legal reviews, things of that nature. So as you progress, they move you on in almost like a little circuit.
So that would include defending at some point, perhaps?
Possibly, if I chose it. The Army sometimes cares about what you want, and then sometimes it's just the needs of the Army. So wherever you're best suited, your skill set, and wherever they need you is where they're going to put you.
Is this your career?
I'd rather not comment on that right now.
Fair enough. Let's go back, though, a little bit to the class that you taught.
Yes.
You commented that the course book that you used, first of all, you didn't write the book.
No, I did not.
It was a book that was suggested or?
Suggested. I think the previous professor used that book, and when I spoke with the director of the legal department, they said, hey, this is the book that we normally use. Take a look at it. It seemed pretty straightforward, standard book that you would see in a criminal law course.
But it was not Florida law.
No, not specifically. I think they probably maybe reference majority, minority of states, but I don't think they ever probably talked about Florida specifically in that book.
Oh, I was just looking for the other exhibits for a second.
So I have them.
Let me take a look at
Sure.
what we got here. So the textbook that you used, thank you,
Sure.
was not specifically focused on Florida law as much as it was sort of a general discussion of a great many topics within this broad subject of criminal litigation and procedure?
Yeah, but then, I try to supplement that with other materials and things of that nature, discussion to focus them on Florida distinctions, because I felt it was important, even with respect to other criminal procedures and things of that nature. I felt giving the students some sort of focus, concentration on Florida law was important, so I did that.
So, for example, in part of Exhibit 210, it's an excerpt from the book that says self-defense, and I'll have you just
Sure.
take a look. Just that this isn't a specific discussion of Florida's self-defense statutes or what has been characterized as stand your ground.
Negative.
So that's true, it's not.
Yes, that's true. It is not.
Okay. So your discussions then that would be more focused on the laws in Florida would have been in the class,
Yes.
not in the textbook.
Correct.
Okay. as a member of the Florida Bar, then you took the bar exam and
Yeah.
had to learn Florida law in addition to the more broad general principles.
Yes.
So you had an understanding of Florida law as it relates to self-defense, specifically because of the Florida statutes.
Yes.
Just for the jury's benefit, a statute is a law that's been passed by the legislature and
Codified.
codified. So
Right.
when we say a statute, that's what's written in the law book.
Yes.
So the law of self-defense is written in Chapter 776, Florida statutes.
I'm not sure the chapter and verse, but if you say so, yes.
Do we have it, just to take a look? This is not a trick question.
No, it's fine.
Is it on your? We'll come back to that
Sure.
in a second. But the idea is that the laws that are passed by the legislature and then usually signed by the governor and then become law are known as statutes, and they're in the law books.
Yes.
And that then becomes the law of the particular state where the legislature has acted.
Yes.
And you are familiar, generally, again, I won't ask you the specific wording, but you're generally familiar with the law of self-defense in Florida.
Yes.
You talked a moment ago, for example, how the stand your ground had evolved from the castle doctrine.
Yes.
Stand your ground is sort of a nickname for the statute. The statute itself isn't titled Stand Your Ground.
No,
or such
I don't
thing.
think any legislator would write that such a way, but it's a nickname.
So the is the word codification? The codification of the castle doctrine became Florida's stand your ground law insofar as the use of self-defense.
You can say that, yes.
The castle doctrine is the notion that if you are in your castle, in your home, and you are attacked, you have no duty to retreat, even if you can. You have no duty to retreat. You may meet the force with force to defend yourself.
Yes.
Am I right generally on that?
Yes.
And then by the evolution of that doctrine into what's been generally characterized as stand your ground, what it did, basically, was allow someone to defend themselves outside their home if they are attacked,
Correct.
without the duty to retreat.
Correct.
Before that, if you weren't in your home and you were attacked, before you could use deadly force, you had to retreat if you could.
Yes.
If you safely could. So in other words, if there's an attack outside, you have to sort of assess the situation, decide.
Let me hear the rest of the question, and then you may approach.
Under the old law, with the duty to retreat, if you weren't inside your home and you were attacked, you would have to assess the situation and make a decision at that moment whether or not you could safely get away before resorting to force.
Yes.
You may approach.
Thank you, Mr. Carter. We're back. The discussion that I'm having with you now about the Castle Doctrine and this law that's become known kind of by the nickname Stand Your Ground was the part of your classwork that wasn't contained in the book. Is that right?
Yes, it was not contained in the book.
Because of your training as a lawyer, having passed the Florida bar, been admitted to the Florida bar, and indeed working in the public defender's office, you were using that information and your understanding of Florida law to talk about these issues with your classes.
That is correct.
Okay, so what we were talking about then was the evolution of the Castle Doctrine into what the legislature did some, like 7 years ago, 6, 7 years ago, something like that, into what's been known as Stand Your Ground. So
Right.
that's sort of the focus.
Right.
Okay. The Castle Doctrine was this idea that if you were in your home,
Objection. Again, same objection.
I think a clarification needs to be made if his answers to these questions are based upon his personal knowledge in his profession, or it's what he taught the class. Can you make that distinction?
Say again, ma'am?
Whether or not your answers to these questions are based upon your knowledge as an attorney in your practice, or are they also something that you taught the class?
The evolution of the Castle Doctrine?
That's the question.
Yeah, that would be something that I hit on in the class.
Then you may proceed. Objection overruled.
so what that means basically is that when you are at the Castle Doctrine, when you're in your home and you're attacked, you don't have to worry about whether you can get away. You may meet force with force.
Right.
Sort of a. And then what happened when the statutes changed a few years ago into this what's been known as Stand Your Ground, basically the Castle Doctrine of no duty to retreat was simply authorized in locations other than your own home.
Right. I think what would happen is the presumption change. You know, if you're attacked in your home, there's a presumption that you're in fear of your life. A lot of times attacks happen at night. You're scared. You've been woken up by something. So there was a presumption that you were in fear of your life. So that's how that came about. And then it extended outside of the home. But there wasn't that same presumption. That same presumption doesn't exist outside of a home. It's dwelling, residence, I think your vehicle is where that presumption is. But outside of the home, there wasn't that same sort of presumption. I hope that makes sense.
Well, I know you're taking us to school, so let me clarify a couple of things. You're suggesting that when the attack occurs in certain locations, in addition, is there no duty to retreat, but there's sort of a presumption that if it happens, that you will be in fear for your life.
So yeah. So if you're in your home, that's in your home. There's a greater indicia that that person had a reasonable fear of death or grievous bodily harm.
Okay, but if you're in your home and I don't want to go too far away from why you're here testifying today, but I want to clarify, though, that part of self-defense is, under any circumstance, the reasonable belief that you have to act to avoid imminent great bodily harm.
Oh yes, no question to that. So
There's an objection.
I'm sorry.
My objection is that the framing of the question is counsel's version of the law.
Okay.
And
I'm going to sustain the objection, and and state to the jury, at the end of the conclusion of the evidence of this case, this court will give you instructions on the law that you are to follow and apply to the facts as you find them. Your questioning needs to be as to what he taught the class, not a general discussion on what the law is.
Yes, ma'am. Thank you. So when you taught the class, what is the core concept of self-defense when you can use deadly force?
When you have a reasonable apprehension of death or grievous bodily harm. And the term reasonable is obviously has two components. So there's a subjective component, meaning that I feel like I'm in fear. In my mind, I feel like I'm in fear of death or grievous bodily harm. But when stuff hits the fan, you're judged by jurors. And your actions have to meet a reasonable standard objectively. So whether or not a reasonable person in your position would have felt the way you felt.
All right, so what you would explain then to anybody that was there that day would be that on the issue of the reasonable fear, it's both subjective and objective. The subjective part is crawling inside the person's head to see what they were thinking and would it be reasonable to them that they would fear for their life.
Right, and that's why the totality of the circumstances are important.
Mm-hmm.
For example, if you approach me right now in broad daylight, whatever the case is, I probably wouldn't have that much fear. But, you know, the lights are out, I don't know what's happening, I feel someone grab me. Those are circumstances you need to consider and whether or not someone had a reasonable apprehension of fear.
So the first part then is trying to understand as best you can from the totality of the circumstances whether that person was in fear in their own mind. Did they think that serious bodily harm was about to happen?
Right.
And then you're saying then there's a bit of a shift. And then in order to see if that's reasonable, then the trier of fact, if you will, the jury then looks at this idea. Does it make sense that somebody in that person's situation, with all of the circumstances, would fear that they were facing imminent great bodily harm?
That is correct.
Nowhere in the discussion of self-defense is it required that the person being attacked actually be injured. It's really the issue of what they think is going to happen, not what's actually happened. Is that right?
I'm going to object again.
Okay. The court will instruct the jury on whatever the law is at the end of the case, and that is the law that you are to apply to the facts as you find them. Your discussion today is limited to what you have taught in the course.
Yes, I understand.
Mr. Carter, the presumption is that any question that I ask you today is either to clarify an answer that you've given, to explain the legal concept, or connected directly with the way you would explain these things to your students.
Right. I understand that.
I'm not going outside the scope of that.
Understood.
So what you just explained is how you would explain this self-defense concept works in Florida.
Right, and it's fluid. You know, the law as it applies isn't static. Like I said, any change in a certain fact can weigh differently in terms of whether someone acted reasonable. And you know, to illustrate that, I would put up examples on the projector. I would have YouTube videos and pause it frame by frame. Okay, what's happening now? You know, what is this person justified in doing? What are they not justified in doing? And so you can see that, you know, things can change in a matter of moments.
An encounter that doesn't appear to be deadly can turn deadly pretty quickly in your mind.
Oh, yes. Yeah.
On the issue of injuries, though, when you talk about that with the class and your understanding of the law, is that the focus is what's going on in the person's mind, not whether they have actually been injured. It's the fear of the injury, is it not?
It's imminent injury, imminent fear. So the fact alone that there isn't an injury doesn't necessarily mean that the person did not has a reasonable apprehension of fear.
Mm-hmm.
The fact that there were injuries have a tendency to show or support that that person had a reasonable apprehension of fear. But the fact that there wasn't an injury at all doesn't necessarily mean there was a reasonable apprehension of fear. You know,
You don't have to wait until you're almost dead before you can defend yourself.
no, I would advise you probably don't do that. Yeah.
And I take it, when you're under attack, you never really know where that moment will be.
No, unfortunately, you don't. And that's not even something from our. That's something that I think a lot of the students grasp. You know, I think we've all, and they have all probably had situations where, you know, a tussle maybe became more than just a tussle. So things can change.
For example, things can change that a situation that may not have appeared to be deadly or the risk of great bodily harm at first can develop into that.
Yeah, and we also talked about imperfect self-defense, where you may have started out being the person that was attacked, but for whatever reason, you took it a step forward, and now you're the aggressor. So that dynamic between, you know, two people involved in a fight or a scuffle, that could change.
You use the term imperfect self-defense.
Right.
Is that the notion that sometimes the tables can turn?
It means that, or also means that the person acted unreasonably in countering the force that was applied to them or approached with them.
Hypothetically speaking, this discussion that you started, if I'm approaching you,
Right. So if you're approaching me,
and let's say that I push you.
yeah, it'll be a little extra if I picked up a video camera and knocked you upside the head. That would be a little extra, and that would probably be an imperfect self-defense.
So let me see if I'm clear. What you would explain then would be, for example, I'll use the hypothetical that we started here. So if you and I were facing each other, and I pushed you or bumped you, and you reacted in great disproportion to what I did, then it turns, and you could put me in fear for my life, and then I would have the right to defend myself at that point, even though, under the hypothetical, I may have started it.
Yes.
So in that situation, I would be trying to figure out what's going on. How far are you going to go?
Yes.
How much danger am I really in?
Yes.
And under that scenario, would it be reasonable that if I were screaming for help and you didn't stop over a period of 10, 20, 30 seconds, that I screamed for help, making it clear I wanted no part of this, then I would have then an appreciation that you weren't going to stop.
Judge, I'm going to object to the continuing and the specificity of the hypothetical.
Sustained.
Without the specific details that I'm talking about, that's what you're talking about, in a sense that it really doesn't matter. The focus of the self-defense is at the point that the force is used. And it's only really a relatively minor consideration as to what actually started it.
Objection again as to counsel positing things.
Right, if you will rephrase your question, because you begin it with the former hypothetical that this court sustained. So if you'll rephrase your question, please.
I will. I'll try. Thank you. When you're talking about what you call the imperfect self-defense, what you're really talking about is when you're involved in a situation with somebody, even if you start it, but the tables get turned, and then all of a sudden you're the one that's being attacked with far more force than you used. That's the scenario I'm talking about.
All right, so let's repeat back what you're asking. So, basically, in a sense, if someone initially feel that they were being threatened, and they countered that threat with a force that was disproportionate to the force that was directed towards them,
Right.
yes, that would be an imperfect self-defense claim or imperfect self-defense scenario.
So even under that scenario, the person that may have started it with some lower level of force, and the table turns on them and there's a great level of force, a disproportionate level of force, they have the right to defend themselves.
Right.
So actually, yeah. We're continuing number one, the same hypothetical. Number two is too specific to.
I'm going to overrule on that one, and the answer was given.
I didn't hear the answer. Would it be read back? You agreed?
Yes.
May I have just a moment? Thank you, Your Honor. Captain Carter, thank you.
You're welcome.
Any redirect?
Captain Carter, as you discussed in the context of all this, is when you're talking about the self-defense law, the idea of claiming it when you. Yes, Your Honor. The idea of claiming it when you have provoked the action. That enter into the discussion?
Objection, Your Honor. May we be heard at the bench?
Yes. You may proceed.
Thank you. If I could, you're talking about the imperfect self-defense. Is
Right.
that discussion of sort of provoking use of force? Is that included
Say again?
in your concept of imperfect self-defense?
Right.
Where you talked about from starting as an aggressor to moving to something else. Is that sort of provocation? I mean, is that the concept you're underlying with that, or is that not what you're talking about?
What I'm talking about when it comes to imperfect self-defense is a situation where you do not meet the force that, or the force that you are encountering, you meet that force disproportionately. It's excessive force.
So I guess then the ultimate level of force in these scenarios is deadly.
It's deadly force,
Like a gunshot.
like a gunshot.
No other questions, Judge? Thank you.
Thank you, Captain.
Thank you. May Captain Carter be excused?
Yes, Your Honor.
Thank you very much, Captain Carter. You are excused. I'll call your next witness, please. Anybody need a recess? No. Call your next witness, please.
Call Jim Krzenski, Your Honor.
Raise your right hand. Do you solemnly swear or affirm that the testimony you shall present will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, I did.
Thank you.
You may proceed.
Thank you. Mr. Krzenski, would you please go ahead and spell your last name for us? In particular, tell us where you are, or I'm sorry, where you work and what you do.
The spelling of my last name is Krzenski. And I'm the Administrative Services Manager for the Sanford Police Department. I basically oversee all the administration of the police department and report directly to the Deputy Chief.
And by administration, does that include the records that the department keeps and maintains?
Yes, I have 4 records technicians that report to me.
Okay. Sir, I'm showing you what State's Exhibit 212. Is this one of the types of records that you just referenced kept by the Sanford Police Department?
Yes, sir.
Okay. And you've seen records like that before?
Yes, sir.
And what is it?
This is a Sanford Police Department writer release form.
When does a person fill out a form like that?
When they request to ride along with a police officer.
And was this filled out by a particular individual?
Yes, sir. There is a particular individual here.
And who was it?
George M. Zimmerman.
And when was it filled out?
It was filled out, according to this, on 3/15/2010.
Okay. And does the person indicate whether or not they have a reason for wanting to go on these ride-alongs?
Yes, sir.
And what is that reason?
It states here, solidify my chances of a law enforcement career, I believe, a career in law enforcement.
Thank you. Your Honor, I'd move State's Exhibit 212 then. No other questions.
Okay, we'll come into evidence of State's Exhibit 212. Cross, please.
Very briefly, Your Honor, thank you. Morning, sir, how are you?
Good morning, sir.
You, of course, reviewed all of your available records to come up with the one time that Mr. Zimmerman sought a ride-along with a police officer, correct?
Yes, sir. We searched for this record. We have literally hundreds of these, yes, sir.
Sure, and there was only the one where Mr. Zimmerman did that back in 2010?
Yes, sir, to my knowledge.
Never requested it again?
To my knowledge, no.
Were you aware at all in your records that Mrs. Zimmerman had responded after that ride-along, talking about the officer that he had rode along with?
Not directly, sir, no.
Not in any of the records that you keep that when you were looking for that record?
No, sir.
Okay.
I didn't find anything related to this ride-along other than this form right here.
Okay. Then I have no further questions. Thank you, Your Honor.
Thank you. May Officer Krzenski be excused?
Yes, Your Honor, please.
Okay, thank you. Do you may be excused, sir? Call your next witness.
Could we approach, Your Honor?
Yes. Ladies and gentlemen, the next witness that is going to be called is going to be appearing by Skype, and that's not scheduled to happen till 11 o'clock today, so we were a little ahead of schedule. So instead of just sitting in the courtroom or starting with another witness and stopping at 11, we're going to take a recess from now until 11 a.m. So if you'll please put your notepads face down on the chair and follow Deputy Jarvis outside the courtroom. Please be seated. Court will be in recess until 11 a.m. Court is back in session. Are we ready to bring the jury in a moment?
We're having an issue with the audio, Judge.
Okay.
I know this shocks everyone. Mr. Pleasance, can you hear me?
Yes.
Yes, I can hear you.
Because I cannot hear you.
Let me try this. How's that? Not working? Okay, I can hear
Can
you.
you hear me?
Yes.
Okay, I cannot hear you.
Try that. Speak again. Can you speak again?
Testing 1, 2, 3. All right, I can't hear you though. That's the issue. Let me get with them, see if we can work it out. I'll keep the phone on. Lou, they can hear me. All right, try now.
All right, can you hear us now?
Oh, it sounds like a chip.
Yeah.
Sounds like what?
Exactly like it. Can you sing a Christmas song? If needed, maybe I can hook up my iPhone, so maybe that'll as well.
I do have a proposal. We can leave the phone on for the audio that way.
Yeah, as long as we can hear him. If he can only hear you through the
We'll do that.
phone.
I'll do that. think
They're
we're,
gonna get their, pull up my laptop and see if that works better.
well, I have an alternate solution. You can hear us fine, right?
Yeah, I'm on the phone.
Well,
Okay.
we can hear him.
We can speak to you this way, and we can hear
Well,
you
we
fine.
can hear him. He can't hear us, is it?
Yeah, we can.
You can't hear us through Skype, you can hear us through
The phone.
It's just their speaker system and that.
I understand. We can actually just ask our questions through this phone call. Go ahead and have a seat at the camera.
Okay, we can do that. We're just gonna, oh, okay. I'm gonna turn this off.
No. Don't turn that off.
Are we turning off the sound?
That was just my volume.
Leave your volume on so we can hear you, and you will hear us through the phone. Got it?
Yeah, I was turning down my volume for the meeting.
Okay. We'll proceed like this. That work for you?
Yeah.
Okay. Thank you.
Okay, let's go ahead and bring the jury in.
Jury's present, Your Honor.
Please be seated. Mr. Manti, call your next witness.
Thank you, Your Honor. We call Professor Scott Pleasance.
Raise your right hand, please. Do you solemnly swear or affirm that the testimony you shall present will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you.
Professor Pleasance, would you go ahead and make sure you spell your last name for us, please?
It's Pleasance, P-L-E-A-S-A-N-T-S.
And I understand you are testifying remotely at the moment. Where are you at, sir?
I'm in Delta, Colorado, on the west side of Colorado, Delta County District Attorney's Office.
Let me get that fixed. And Professor, can you still hear us okay?
Yes.
Professor, where do you teach courses at?
Seminole State College of Florida,
How long have you been a professor there?
3 years.
Okay. And do you teach a course that is variously entitled Criminal Investigation?
Yes, I do.
I'm holding up a green and blue book. Can you see it?
Yes, I can.
Is that a copy of the course book that you routinely use in the course?
That is one of the books, yes.
Okay. And I've previously shown you what's State's Exhibit 201. Is this just a packet with some excerpts from that textbook?
Yes, it is.
Okay. Do you remember teaching the course in terms of 2010?
Actually, it's 2011, summer of 2011.
Summer 2011, is that when you had a student named George Zimmerman?
Yes.
Okay. And specifically, simply as it relates to the course, what sorts of things do you cover?
We cover various aspects of criminal investigations, the duties of a criminal investigator, some of the constitutional issues surrounding criminal investigations, and basically different aspects of different types of crimes.
Okay. Your Honor, I would move State's Exhibit 201 into evidence.
Okay, 201 will come in as State's Exhibit 201.
And made the previous objection, we would just renew that, Your Honor.
Yes,
403
pursuant to the
inquiry.
court's order.
And Professor Pleasance, the course that you teach, is that sort of an in-classroom course, or is it a different type?
No, this is a distance learning course where we teach it online and requires activities by the student and that's based on the coursework in the book.
I'm sorry, would you go ahead and repeat that starting from the beginning?
Yes, is it coming across?
Go ahead.
Okay. Could you repeat the question?
Sure. Is this a in-room course, or is it a different type?
No, this is a distance learning course where the students are online and I facilitate the class, do the textbook discussions, and a workbook exercise.
Okay. And how do you facilitate those types of discussions?
Basically, we have a discussion forum that is...
Start again, please.
And,
Start that answer again.
we have weekly discussion forums starting with an introductory discussion where each of the students introduces themselves, what types of things they're going for, what their career goals are, and then each week we have discussions.
Okay.
Those weekly discussions are based on different topics.
Okay, and as I understand the excerpt in State's Exhibit 201, there are chapters on how to testify as a witness, as well as on psychological or criminal profiling?
Yes, sir.
Okay, thank you. No other questions, Your Honor.
Okay, Cross. Is that his phone that's getting those messages?
It's someone calling the destination, Your Honor.
I get it.
Just hit decline.
I have no control over this computer.
That's all right.
Hold on, I'm just flying.
I gotta tell you, there's now a really good chance that we're being toyed with, just so you know.
I will do that. Nope.
All right.
Is there another phone that we could call into?
It's gonna take.
That's not a cell phone? Is there a
I have somebody
landline
trying to call in on this side.
there? Okay. Turn down the volume. Is there another phone that we can call into that is a landline that we will not have the pop-ups of people calling?
Well, the pop-up that they're calling on is the landline.
Hang up the phone.
Yes, sure.
It's off now. It's not hung up, but it's off. You take.
No,
Hang up.
I don't want those up on the screen.
Yes, Your Honor.
Let's find another phone number that we could call Professor Pleasance on.
Okay.
Let me just get rid of the whole thing.
Professor, we are going to call you on a different line. Okay, can we call you back on this cell line? Okay, because it's the Skype that's the problem. It's the landline you're using. Okay, thank you. I will leave you on the phone with him.
Great.
So, there's a speakerphone function if you want to use it.
We just hung up. We
Call him
can
back.
back.
That's fine.
We can use yours, right?
Sure.
Just get out of Skype completely.
It's out.
Yes, Professor, hi, this is Mark America. Can you hear me?
Yes, I can. It looked like somebody was trying to call in this computer.
It looked like about 4 dozen people were trying to call in once they realized what number they can call and get on TV, I think. But hold on 1 second, okay?
Could you put that up to a microphone?
Would you go ahead and just tell me your name again?
Gordon Paul Pleasance.
Can you hear it?
Okay, we'll try it again. We're just trying to set up some audio problems. I'm going to try that again and ask that you tell me, and just hold on 1 sec. Say your name again.
Gordon Paul Pleasance.
Does that work, Your Honor?
Yes, thank you.
Just have a second to get reorganized.
He said his name, Pleasance, Pleasants.
other options if this doesn't work. I have a speaker I can hook up to if I'm going to try this. So we'll see where we go. Because I'm afraid of feedback with my voice. Again, just to check and make sure that the audio is now working okay. Tell me again how long you have been working for at Seminole State College.
Approximately 3 years.
Is that acceptable? Okay. And if I might first,
Yes, you may.
again, good morning, Professor. My name is Mark O'Mara. I represent George Zimmerman in this case, and I have a few questions to ask you, okay?
Okay.
Great. You mentioned, I think, that this, in fact, was an online course, correct?
Correct.
And there was no classroom appearance, correct?
There's no required classroom appearance. I did have a mock crime scene where students could voluntarily attend, which Mr. Zimmerman did.
Great, and we'll talk about that a bit more in a second. There was also a course book that was identified, correct?
Correct.
But in order to take the tests or the quizzes you gave, was there a need to actually read that book?
There weren't actually tests for this course. We actually had a workbook where they would investigate a homicide from the beginning to the end, and the textbook was to assist with that and the discussions.
Okay, so when I look at State's Exhibit 201, which is an excerpt from that textbook, you could not give testimony today that this was even covered in class, correct?
Yeah, I can't guarantee that that was discussed back and forth with the students.
Well, yeah, and again, we may have some audio difficulty. I'm going to ask you to repeat that last question when I asked you that you could not even tell us here today whether or not this was even discussed in class, correct?
Yes, or if he read the material.
Or the, excuse me?
Or if he read that material.
Or that they read that material. So it cannot be your testimony here today that, for example, Mr. Zimmerman, being a class participant, even read any of the book, correct?
That's correct, and we do have students that do that.
And this portion that talks about profiling, geographic or criminal profiling, there was no coursework that even touched on that subject, was there?
No, there was not.
There's also another one talks about strategies for excelling as a witness. Was that discussed in coursework at all?
Let me check. That might have been a discussion topic, but give me a second.
The second half of that question again, sir?
Yes, sir.
Answer?
I said I need to check. That might have been one of our discussion topics.
Okay. And can you testify? Can you testify here today whether or not George Zimmerman was even present for any of that discussion on the online course?
He was participated in all of the different discussions that we had.
And how is that documented, just so we know?
It's through the Sakai management system, and any of the discussions that we have, since they're in writing, they're maintained, and I can pretty much go back at any time and look at those.
And I'm sorry, the last half of that answer, sir?
I can go back at any time and look at those discussions that the student participated in.
Okay, and now are those records somewhere available to you?
Yes, they are.
Okay, you don't have them with you today, though?
I actually have printouts of the discussion. That's what I'm looking through right now to see if we covered testimony.
Okay, well, maybe we'll take a moment to see if you can review those and then tell us about that. Just repeat that one more time, if you would, sir.
On review of the material showed that it looks like that was not covered in discussions.
Okay, so the issue concerning strategies as a witness testifying under cross-examination were not covered in your coursework?
Is more than one. The book was
I'm sorry. I'm going to ask the question again because I couldn't understand your answer. Understanding again that we have some audio difficulties. Was there any discussion about testifying or acting as how to be a witness in your coursework? Yes or no?
like I said, it was part of the required reading, but we didn't address it in the discussions or the actual course.
Okay. It was in the book, correct? Sir, it was in the book, correct?
Yes, it was.
Okay. But it was not discussed in any of the coursework. Is that also correct?
It does look like it was not discussed.
Okay, thank you. And in preparing, in applying for the course, you actually had the students fill out an initial information sheet, correct?
No, we did have an introduction discussion the first week of class.
Okay, and in that introduction discussion, what did George Zimmerman tell you was his career goal?
He said that his goal was to become an attorney and eventually a prosecutor.
He wanted to become an
An attorney and prosecutor.
attorney and eventually a prosecutor.
Yes.
And that was his career goal that he gave to you back in 2000 and I think 11, you said, in summer?
Yes, he posted that on June 23rd of 2011.
Okay. I'm going to have a moment, Your Honor.
Yes, you may.
I don't have anything else. Do you have any?
No, you
Okay,
Then I can just-
Mr. Pleasance, you are excused. Thank you very much, sir.
You're on speaker. Did you hear that the judge just excused from further testimony in this case?
Am I excused?
Yes, you are excused by Judge Nelson. No other questions. Appreciate your time.
Thank you for your assistance. State, call your next witness.
Amy Sieward.
Do you want to ask you to come in? Can you approach for just a moment?
Yes, you may.
Do you solemnly swear or affirm that the testimony you shall present will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you.
You may proceed.
Good morning, ma'am. If you please tell the members of the jury your name
I'm Amy Sieward, S-I-E-W-E-R-T.
and how are you employed?
I am employed by the Florida Department of Law Enforcement, Orlando Regional Crime Laboratory.
How long have you been with FDLE?
11 years.
And your current position is what?
Crime Laboratory Analyst assigned to the firearms section.
Explain to the members of the jury what your duties are as a crime laboratory analyst in the firearms section.
Sure. My duties as an analyst are to examine submitted firearms for safety and function, to examine fired ammunition components that are submitted as evidence to determine if they've come from a particular firearm, as well as distance determinations on clothing.
And how long have you been an analyst in the firearms section?
I've been an analyst for 3 years.
How long total, or you said you'd been in the with FDLE for 11 years. What did you do prior to being an analyst in the firearms section?
I was a forensic technologist for 5 years in the firearms section, and previous to that, 3 years as a forensic technologist in the toxicology section.
And what did you do as a forensic technologist in the firearms section?
I performed function examinations on firearms.
If you would share with the members of the jury, please, your educational background.
I have a Bachelor of Science degree in chemistry.
And what training have you had to prepare you for your duties as a crime laboratory analyst in the firearms section?
As a forensic technologist, I completed a 6-month FDLE training program, which enabled me to perform function examinations on firearms. And as an analyst, I had an additional 14 months of structured hands-on training in firearms identification. And this included units on firearm operating systems, cartridge case and bullet comparisons, as well as muzzle to object distance determinations.
Have you ever been qualified as an expert in the courts of the state of Florida in the areas of firearm function and identification?
Yes, I have.
How many times?
17.
At this time, I would tender Amy Sieward as an expert in the area of firearm identification and function.
She may testify as such.
Have you had an opportunity to analyze any evidence in the state of Florida versus George Zimmerman under the FDLE case number of 12-05-01890?
Yes, I have.
And specifically, did you examine a firearm and holster in this case?
Yes.
Y'all may approach the witness.
Yes, you may.
Ms. Sieward, let me ask you to look at 154. Just ask you, do you recognize that?
I do.
And what do you recognize that to be?
This is the firearm and holster and magazine that I received as part of this case.
All right, would you open the exhibit then?
Yes.
How do you recognize it to be the same firearm that you analyzed in this case?
I recognize it by the FDLE case number, exhibit number, and my initials.
And what type of firearm is it?
It is a 9mm Luger caliber Keltec model PF9 semi-automatic pistol.
And what do you mean by semi-automatic?
In very basic terms, semi-automatic means that a pull of the trigger is required for each shot to be fired.
And what do you mean specifically by 9mm?
9mm refers to the caliber of ammunition that the firearm is designed to fire.
Are you familiar with that brand of firearms, the Keltec brand?
Yes.
How so?
I've had the opportunity to tour their manufacturing facility twice, as well as I have examined many of them over the course of my casework.
And did you examine the firearm to determine whether or not it was in working order?
Yes, I did.
How did you do that?
I did a general firearm exam. I took note of the make, model, and serial number, looking at the overall condition of the firearm to determine if it looked safe to test fire. After determining it was safe, I used laboratory and evidence ammunition and the submitted magazine to test fire the pistol.
And what did you find when you test fired the gun?
It was functional.
Your Honor, may she step down to demonstrate in front of the jury?
Yes, you may.
Ms. Sieward, if you would step down with, I'm going to grab the exhibit for you. Grab the whole thing. Your Honor, there's a gun lock on the exhibit. May I remove that so she can explain the function to the jury?
Yes, you may.
All right. If you would. Just.
Make sure, can you give it to the deputy to clear the gun?
I was going to ask that, and
Yeah.
I was going to ask if I could move to a
You
vantage
may.
point to see her.
You may do so.
Say it, Your Honor.
All right. Ms. Sieward, if you would explain to the members of the jury how that firearm and anything else you need is for, in terms of the magazine, how it functions.
Absolutely. I'm going to start real quick with a basic definition for you. Right here is what we call a cartridge. It's commonly referred to as a bullet, but it contains at the very top of the bullet the cartridge case at the head of primer and inside of it, gunpowder. Now these cartridges are loaded into a magazine, which is essentially a container for these cartridges designed to feed into the firearm itself. So cartridges are loaded one on top of another in the magazine. The magazine is then inserted up the magazine well of the pistol, and then the user, typically this is closed, the user will pull back on the slide and release. And as they release, the top cartridge from the magazine will be removed from the top and loaded into the chamber, and the pistol will be ready to fire. In order to fire a shot at this point, all you need to do is pull the trigger.
All right. And is there a way to load the firearm so that you don't need to pull the slide back to chamber a round?
You have to pull back on the slide to load a cartridge into the chamber. That's the only way to get it in.
All right. If the magazine was full, could that be done?
Yes.
All right. Explain to him how that is.
With a loaded magazine with the capacity of this particular one is 7, you can pull back on the slide and release, and it will load that top cartridge. Then there'll be 1 in the chamber and 6 in the magazine. If you desire, you can release the magazine, load another one so the magazine would be full for a total of 7 in the magazine, reinsert into the pistol, so the total capacity between the magazine and chamber it'll hold is 8.
All right. Do you recall how many cartridges were with the firearm when you received it?
I received 7 cartridges total.
All right. And the magazine holds how many?
7.
All right. So if that firearm had been fired with 7 in the magazine, does that mean that someone had to place a live round in the chamber?
With the way I received it with 6 in the magazine and an additional 1, it would be consistent with the magazine fully loaded and 1 in the chamber at the time it was fired.
All right. And does that firearm have any features that prevent an accidental discharge?
Yes, it has internal safeties. It is double action only, which means that the firearm cannot be cocked unless the trigger is pulled. Pulling the trigger will both cock and release the hammer, which is located back here. It's also shrouded, so you cannot get to it to be able to cock it. It also has a hammer block, which is a mechanical piece that prevents the hammer from being in contact with the firing pin unless the trigger is pulled, and then that will drop out of the way and allow the hammer to hit the firing pin.
What do you mean by trigger travel distance?
Trigger travel distance is the distance that the trigger has to be pulled rearward in order to release the firing mechanism, or in this case, cock and release the hammer.
And what's the distance or relative distance of the trigger travel distance on that particular firearm?
This particular gun has a longer distance than most typical pistols.
Is that another feature that would help prevent an accidental discharge?
Yes. You have to pull back significantly in order to release the firing mechanism.
All right. Did you also receive a holster with that exhibit, with that firearm?
Yes.
All right. Would you show that to the jury and just show them how the two go together?
This is the holster. There's a clip on the back. Just inserted.
All right. So that would be the total size of it if a person were to wear that on their hip, either inside or outside their clothing.
Yes.
All right. Thank you, ma'am. You may resume your seat. Yes. Could I ask the deputy to do that? Thank you, sir.
While the court's aware, I'll be asking her some questions and using it with the lock off as well. I didn't know if you want to wait. Thank you.
All right. Ms. Sieward, what is meant by the term trigger pull?
Trigger pull is the amount of force required to release the firing mechanism.
And are you able to measure that with any particular firearm?
Yes,
Did you measure that with this firearm?
I did.
Explain to the jury how you did that.
I hung a series of known weights from the shooting position of the trigger where the finger will rest, and I kept adding weights until the trigger was pulled and the hammer cocked and released.
And what did you find when you measured the trigger pull?
It was between 4.5 and 4 3/4 pounds.
And is that within the manufacturer's specifications?
Yes, it is.
Did you also receive a fired cartridge case with this evidence?
Yes.
How many?
I received one fired cartridge case.
Your Honor, may I approach the witness? Ms. Sieward, let me show you states 147. Ask you if you recognize that.
I do.
And how do you recognize that?
F. Dealey, case number, exhibit number, and my initials.
And what do you recognize it to be?
It is one fired 9mm Luger caliber cartridge case.
When you receive a firearm in a fired casing, are you able to determine whether or not that particular casing came from that particular firearm?
Yes.
How can you do that?
With a submitted firearm and magazine, I will use laboratory and/or evidence ammunition to test fire that pistol. I will then collect the fired cartridge cases and compare those microscopically to the evidence cartridge case or cases that I've received.
And did you do that with the shell casing or cartridge case in this case and also the Kel-Tec pistol?
Yes.
And what did you find?
The cartridge case was fired in the pistol.
Did you also receive some bullet fragments in with this case?
Yes, I did.
Your Honor, may I again approach Ms. Sieward? Let me show you states 165. Ask you, do you recognize that?
Yes.
And how do you recognize 165?
Again, by the F. Dealey case number, exhibit number, and my initials.
And what is that? What's contained in that exhibit?
There is one fired jacket portion, two fired bullet jackets fragments, and one lead core.
And when you receive parts of a bullet or fragments of a bullet in a firearm, are you able to compare those to determine whether or not those fragments were fired from a particular firearm?
Yes.
Explain to the jury how you do that.
Similar to the cartridge cases, I'll use the bullets that I've test fired from the submitted firearm and compare those microscopically to the submitted evidence bullet or bullet fragments.
And did you do that with the fragments in this case and the Kel-Tec pistol?
I did.
What did you find?
The fired bullet jacket portion was fired from the pistol. The two smaller fragments were inconclusive, and the bullet core is not suitable for a microscopic examination.
All right. And when you say inconclusive, what do you mean?
I was not able to determine whether they were or were not fired from the pistol.
And why is that?
A lack of detail on them. They were very damaged. They had very small portions of rifling on them.
All right. Is it apparent that those fragments hit something, the bullet, and caused it to fragment like that?
Yes.
All right. Did you also receive some clothing in connection with this case?
I did.
And if you receive clothing in connection with a firearms case, are you able to determine or attempt to determine the distance between the muzzle of a firearm and the clothing at the time the firearm was fired?
Yes.
How does that work? How do you do that?
When a gun is fired, a cloud of partially burned and unburned powder particles, vaporous and particulate lead, as well as smoke and gases, will follow the bullet out the barrel. This cloud can potentially leave a pattern on an object, or if the firearm is in contact with a particular object, no pattern will be left, but other physical effects will be present.
All right, and did you conduct those tests in this case with the clothing you received and the 9mm pistol?
I did.
All right, Your Honor, may she step down again?
Yes, she may.
Thank you. Let's see, well, let me ask you to stay right there if you would. You want to take that over there? Actually, let's put it down. Ms. Sieward, if you would join me over here briefly. Mr. Doriano, can you give me the exhibit number?
155.
All right. Let me ask you to examine the packaging from 155 and tell the members of the jury whether or not you recognize it.
I do.
And how do you recognize it?
F. Dealey case number, exhibit number, and my initials.
All right. And is this an item of clothing that you examined in this case?
Yes, it is.
And conducted distance testing on?
Yes.
All right. If you can put that back in here real quick. Lift this up. All right. Explain to the jury first what this is, what you saw, and what you did.
evidence that I examined for a distance determination. And what I did was I was looking at the area surrounding this hole. I was looking for partially burned or unburned gunpowder particles. I was looking for any type of sooting present around this hole, as well as looking at the ends of the fibers as to whether they were blackened or singed or melting.
And how did you?
Whether they were blackened or singed or...
Melted.
Okay, yeah, if you would just stand back just a little bit so the court reporter has a visual of you, that would help. What did you do to test fire with this particular item? Did you take a cutting from it, or what did you do?
I did. I removed a portion of the back of the sweatshirt for testing purposes.
All right, and Mr. Delaron, if we could turn this around real quick. Can you show the members of the jury where you removed the fabric to conduct your test?
Right in this area.
All right. Mr. Delaron, if we could go back that way, and this way. Thank you. Ms. Sieward, just from there, is this the fabric that you removed that we see on the exhibit on the back?
Yes, it is.
All right, is that having a test fire hole in it?
Yes.
Okay. Let me ask you, Mr. Delaron, if you'd grab that packaging out. $156. You recognize the packaging?
Yes.
How do you recognize it?
FDLE case number, exhibit number, and my initials.
And this is obviously a sweatshirt that you examined in the case?
Yes.
And again, if you can show the members of the jury the area that you focused on as having a bullet that passed through it.
This area right here was where I was looking right underneath the Nike swoosh.
And as with the previous exhibit, did you make a cutting from the exhibit?
I did.
All right, and is that depicted on the back of the exhibit, if you would just come around and look?
Yes, it is.
Okay, both the cutting and then the area on the sweatshirt where it was cut out?
Yes.
All right, let's just show that to the jury real quick. And that's been displayed, again, with a bullet hole through it from your test fire?
Yes.
All right. You may resume your seat. In conducting the test fires, did you capture your analysis with photography?
Yes, I did.
All right, let me ask you to look then at States 122. Your Honor, if we could have assistance with the lights. And if I may approach the witness.
Yes, ma'am.
Give me this laser pointer. It works by depressing that button right there at the top. What is States 122 first?
This is a picture of the outer sweatshirt that I had examined for distance determination.
All right, and explain to the members of the jury just the significance of the items that you've marked on the exhibit.
Sure. This is an overall shot of the sweatshirt. I measured the distance about 9 inches down from the top shoulder seam and approximately 7 inches in from the side arm seam.
All right, in States 123, what's depicted there?
It's a little difficult to see with the particular color of the fabric, but what I was looking at here are a few gunpowder particles surrounding this, as well as some blackening right around the hole, as well as some tearing of the fabric and burning and singeing on the fabric ends that were torn.
And is that a close-up, obviously, of the bullet hole on the sweatshirt?
Yes, it is.
All right. States 124, what is that?
That is the inside of that same area. Right here you can see a little better the blackening that I was looking at.
So that's a close-up of the inside of the sweatshirt?
Yes.
All right. In States 125, what's depicted there?
That was the distance test that I had made using a portion of that sweatshirt.
All right, and just take them through how you conduct the distance test, what ammunition you use, and why.
Absolutely. Using the submitted pistol and submitted ammunition, I test fired into portions of both garments that I received. And the reason for doing so is the pattern that can be left behind using a particular firearm or ammunition can vary greatly depending on the length of the barrel, the size and style of the bullet, as well as the amount, shape, and burn rate of the gunpowder contained within the cartridge.
So you actually used one of the 7 live rounds that you received with the exhibit to conduct this test?
Yes.
All right, States 126, what do we see there?
That is a close-up of the distance test that I had made. The arrows are pointing to diagonal tear that occurred in the fabric.
And when you conducted the distance test with the Kel-Tec pistol and the hooded sweatshirt, what did you determine about the distance between those, the muzzle of the gun and the material at the time the gun was discharged?
The clothing displayed residues and physical effects consistent with a contact shot.
Meaning the muzzle or the end of the barrel of the gun was up against the sweatshirt when it was fired?
Correct.
All right, let's go to States 127. What is that?
This is the other sweatshirt that I had received to do distance determination on.
And again, you made measurements of where the hole is relative on the sweatshirt?
Yes.
All right, incidentally, if both of those sweatshirts were being worn in their intended fashion, that is, forward, do the 2 bullet holes line up?
They do.
128, what do we see there?
With this, we are looking at the tearing of the fabric. You can see there are a few gunpowder particles, which are not easily depicted in this photo, as well as some light sooting and burning and singeing of the ends of the fabric.
In the reddish-brown staining, that would be apparently blood?
Yes, it is.
All right, not something that you applied?
No.
States 129, what is that?
The inside of the hole that was in the previous photograph, and again, you can see a little better the sooting, the blackening surrounding the
Can you
hole
circle
itself.
that for the jury as best
Yes,
you can?
Sorry.
Okay. All right, in States 130?
And this is the test that I had generated using a portion of the back of the garment.
And when you conducted that distance test, did you also use the 9mm firearm as well as the ammunition that was present with the firearm?
I conducted that simultaneous to the first one. I had layered the darker sweatshirt over the lighter sweatshirt and fired one shot through both. So this is from the same
Just so we're clear, the hooded sweatshirt you would have put on the outside, the lighter sweatshirt would have been on the inside?
Correct.
All right, and what did you find distance-wise when you conducted the test with this particular sweatshirt?
This as well was consistent with residues and physical effects of a contact shot.
So again, evidencing that the end of the gun was against the material when it was fired?
Yes.
All right. And finally, States 131.
With the lighter color sweatshirt depicting a little better that you can see the tearing and the blackening of the fabric right around the hole.
All right. Are your findings consistent with the muzzle of the gun having been pressed into the dark hooded sweatshirt and then fired through both the dark hooded sweatshirt and the lighter colored sweatshirt?
It is consistent with the muzzle of the firearm touching the outer sweatshirt and the inner sweatshirt being in direct contact with that outer one, yes.
All right, thank you, Mayor. Judge, that's all I have. Thank you.
Okay, thank you. Do you want to break for lunch at this time, or you're
Your
gonna?
call, Your Honor.
Well, I don't know how long you think it'll be.
I think I can probably get through it, so we'll get this witness off the stand. It might take me 15 or 20, but I can't imagine it's more than that.
Okay.
And if I get to 20, you can remind me where we are if I don't notice, but I'll get through it.
Okay.
Thank you. If we really do hit a snag, I may ask that we break for lunch. Good morning, ma'am. How are you?
Good.
Good. I'm going to try and do it sort of the way that you went through it in your direct examination. Obviously, what you've told the jury, you do in a lot of cases where these issues may be in contest, correct?
Yes.
Where you're trying to determine, for example, that the cartridge found came from the gun. Right?
Correct.
You know that's not an issue here, right?
Yes.
And you do a lot of analysis to make sure that the bullet came from the gun in many cases, correct?
Yes.
And you know that's not an issue here.
Yes.
Okay. And concerning the firearm itself, of course, you need to be able to testify to a jury this gun can work and can fire a bullet, correct?
Yes.
You needed to do? Were you given any indication that there was an issue in whether or not this bullet came from this gun?
We're never given an indication whether there's an issue present or not.
Okay. So you would take it on and look at it and see what needs to be done to prove up matters, even if they may not be in contest.
Correct.
Okay. So in this case, you were able to document gunworks, fired cartridge, fired bullet. Correct?
Yes.
Now let's talk about the gun itself. And if I might approach the witness, Your Honor, with the firearm that's in front of her. If you would, I'm actually going to have you testify from where you are right now, but I would ask you to take out the firearm and just hold it, obviously, as you know how to, pointing it nowhere near any of us, including the jury. And I think that you said you have a good history and experience in firearms generally, correct?
Yes.
And you know what different types of firearms are used for?
Yes.
Okay. And that is what's called a double action, correct?
Yes.
Meaning by that you don't need to do, you need to have a certain amount of weight and intent to fire that firearm, correct?
What double action refers to is pulling the trigger, cocking, and releasing the firing mechanism.
And the very characteristic of being a double action is a safety feature, correct? Is ready to fire with a very light, almost featherweight pull, correct?
Those are referred to as single action firearms.
In a single action, if I were to be carrying around a single action without an external safety on it in my hip, it would be quite dangerous, wouldn't it?
If the firearm was cocked.
Of course. If
Yes.
I've racked one in and it's only on single action now because it has a featherweight pull, right?
Yes, it has a lighter trigger pull than a double action.
So the double action characteristic itself makes it a safer weapon to carry in a ready to fire position, correct?
With it functioning properly, yes.
Of course, presuming for the next few questions that we're talking about firearms that act the way they're supposed to act, okay?
Yes.
And you know that some weapons are used particularly for self-defense, correct?
Yes.
To protect oneself, correct?
Yes.
And within that context, a firearm that's to be used for self-defense has to be ready to use, correct?
Potentially.
You would not want a firearm that has an external safety that would, on a double action, that has an external safety that would require an additional step to make it ready to fire, would you, for a self-defense application?
I can't really say as to whether that would be more of a personal preference, I do believe.
Okay, let me ask it this way. If, in fact, one was carrying a firearm and it had an external safety, what would have to happen before that firearm was ready to fire?
The safety would have to be disengaged.
It would have to take that extra step to disengage the safety, correct?
Correct.
This gun does not have an external safety, correct?
No.
What exactly then makes this firearm a safe firearm to carry in a loaded way?
It's a combination of the fact that it's double action, that it's never cocked until you pull the trigger, as well as the hammer block, as I had stated previously, that prevents the hammer from coming in contact with a firing pin unless the trigger is pulled. With both of these safeties functioning properly, the gun cannot be fired unless the trigger is pulled.
So the hammer lock itself is actually an additional safety device, and that basically is a little metal plate that goes between the hammer and the back of the cartridge, correct?
Back of the firing pin.
Firing pin.
Mm-hmm.
So, and if that metal plate is there, it is safe. It cannot fire, correct?
Correct.
And only when you start pulling on the trigger, which has a 4.5 to 4 3/4 pull, does that plate drop in order to make the gun active,
Yes.
correct? And the very nature of having a 4.5 to 4 3/4 pound pull is itself a safety feature, correct?
The trigger pull itself is not a safety feature.
I'm sorry, having to pull the trigger with that amount of force is a safety feature, correct?
No.
Well, then why don't you compare for the jury the pull necessary to pull a double action firearm as compared to a single action firearm?
Are you talking the trigger travel distance?
I'm sorry. I use, yes, the trigger travel distance.
Yes, in terms of the length that the trigger needs to travel backwards to release the firing mechanism on a double action, and especially this one, is much longer than, say, a single action firearm.
And would you agree that that also is a safety mechanism to be certain that that the firearm is not going to fire without someone deciding to make the full pull on it?
That would make it a lot less likely to accidentally pull. It would be a deliberate pull of the trigger.
And are you saying this is not a safety feature, or did I just misstate the word when I was using pull pressure?
It's a design feature of the gun.
To make it safer?
Potentially, yes.
So, is that an appropriate gun then to be carried, or is it a safe gun to be carried in a loaded and ready to fire position?
This gun, again, in working order, is safe in terms of it will not fire unless the trigger is pulled.
There are other guns, of course, as we talked about a moment ago, that have external safeties, which means you need to undo a safety before shooting the gun, correct?
Correct.
Are those more found in single action guns where the trigger distance is much less?
That will be found in single action guns and double action guns and firearms that do both single and double action. It's a mix all across the board.
You do agree that this gun without an external safety is a safe gun to carry loaded?
Safe is a personal preference in terms of loaded. I would say that, again, this gun cannot fire unless the trigger is pulled.
And I don't want to get into qualitative terms of safe or not, but is there anything with this particular gun that you found that suggested it was unsafe to carry in a loaded way, ready to fire?
No.
There are probably at least 2 guns in this room. Would you agree that all law enforcement carry their guns ready to fire?
I do believe they do.
Okay. They're not much use if they're not ready to fire, are they?
No.
You had mentioned even as to this weapon, you've had a chance to visit the factory where they're made a couple of times?
Yes.
It's right here in Brevard County, correct?
Yes.
And you've been there a couple of times to see, do any concerns with the manufacture of that weapon?
No.
From your experience as to how it was utilized in this event, did it Was it, did it perform properly? Did it shoot its projectile the way it was supposed to?
The gun functioned, yes.
Okay. So it worked, correct?
Yes.
And it worked the way it was supposed to?
Yes.
There was no suggestion that the pull distance was malfunctioning in any form, correct?
No, there was no indication that anything on this pistol was malfunctioning.
And you had mentioned now talking, anything that we haven't talked about with the gun and its safety features?
No.
You had stated in response to how you can load that is that you have to, and I call rack it, is that the right term? When you pull back the slide?
Yes, that's
Can
a
we
term
use-
that's used.
Okay, can we use that so that both you and the jury knows that racking it means pulling the slide back to actually put a cartridge or a bullet in the chamber being ready to fire?
Sure.
Okay. And you stated that a person, Mr. Zimmerman, since we know it to be his gun, right?
Yes.
Okay. Would have then racked it to make sure it was in fact ready to fire and then put another bullet in the magazine and reloaded it. Correct?
Yes.
Is that a usual occurrence in your experience dealing with firearms?
I typically
Or
see
did you
a
just
wide
not see it?
variety of,
Okay.
of
You
what
did
I
not
receive.
sorry, I interrupted you.
That's
You did
fine.
not consider that to be an unusual occurrence, certainly,
No.
did you? Okay. Matter of fact, the two law enforcement officers here, and probably every other law enforcement officer gun that you had a chance to see, that is normal, that it is one racked in the chamber and a full magazine, correct?
Yes.
Military do that, correct?
I'm unsure.
It, in fact, is the way that you make that gun as capable as it can be for whatever the need may be, correct?
To have it fully loaded?
Yes.
Yes.
And then we've talked about the shirts themselves, and I'm not going to go into having you look at them just yet. You might be able to avoid that. But you had said that the two shirts sort of lined up, correct?
Yes.
And by that you mean, obviously, there was a hole through one and a hole through the other, and when you took the shirts and lined them up, they matched, correct?
Correct.
You're not suggesting that because of that the shirts are in any particular configuration on the body, are you?
No.
Okay. They were where they were, but certainly the bullet went through both shirts where they were lined up with the bullet hole.
Yes.
Okay. And let's talk about the action when you say contact. Mr. Guy suggested pressed into, and I think you corrected him to say it was touching, correct?
Yes.
There was no evidence, for example, that would show up that you would take the gun nozzle and push it into the shirt somewhere where the shirt would fold around it, was there?
No, it was consistent with the muzzle of the firearm touching.
It was consistent
The
with
sweatshirt.
this, correct?
Yes.
Shirt, firearm, wasn't
Yes.
consistent with this, right? Pushing or anything?
No.
That would have shown a completely different configuration to you, right?
To me, contact is when the muzzle is just touching the fabric,
Okay.
whether it's a light touching or whether it's pressed in all the way. The fact that the muzzle was touching the garment itself was what I had determined.
Right. So certainly had the gun actually been sort of smothered by the shirt or by a sheet, then fired, you would have seen a much different patterning on that, right? Because the fire then would have wrapped back around it somewhat?
Potentially if it was wrapped around it.
Correct.
Yes.
And matter of fact, any configuration that suggests something other than flat would have shown some different stippling potential or burning from the way the flame would then have bounced around, correct?
In terms of farther away or closer?
No, if it was in contact,
Okay.
pushed in to the extent that it folded the fabric around it, that would have shown a different type of burn pattern potentially, correct?
Potentially if the sweatshirt had gone over the top of the ejection port area, there would possibly be marks from that. But otherwise, whether it was lightly touching or pressed in, it would be the same type of physical effects that I had seen.
And when you say touching, is that a term of art actually was touching, or in this case, when you saw a couple of, I thought you said, you saw a couple of little burn spots of maybe powder that had escaped. Was that consistent with being an eighth of an inch away, or a quarter of an inch away, or what?
No, it's consistent with the muzzle touching the garment itself.
Okay. And that you can tell because there was some tearing itself. That is the way that a projectile at that range rips through the fabric?
Yes.
Did you do any examination to identify the distance that the bullet traveled before it hit Mr. Martin's chest?
No, I only examined the clothing for distance determination.
I have a moment, Your Honor. Do you involve yourself then ever during your experience with FDLE to actually look at the injury or flesh wound occurring by a bullet entering it?
No, I do examination of clothing.
Okay, so whenever the bullet, before it gets to the body, is where you stop
Correct.
in your analysis?
Yes.
Thank you, Your Honor. No further questions.
Thank you. Any redirect?
Just briefly, thank you. Ms. Sieward, you were asked questions about whether or not that firearm could be used for self-defense. Could it also be used to commit a murder?
The firearm can be used for any purposes.
Your Honor, I might, because that is speculation and would affect the ultimate fact before the jury, ultimate question before the jury.
Sustained.
You were asked about the trigger pull. Can you give the members of the jury an idea of whether or not 4 pounds or a little bit more than 4 pounds is a relatively light or relatively heavy trigger pull?
4.5 pounds is within the normal range of trigger pulls that I see in my casework.
So it's not a heavy trigger pull?
No, it is not.
And you were asked questions about the firearm being fully loaded. Can you explain to the members of the jury that if the magazine's full and there's a live round in the chamber, on that particular firearm, what must a person do to expel a bullet?
Pull the trigger to fire the gun at that point in time.
That's it. There's nothing they have to turn off or adjust. You just pull the trigger.
Correct.
All right, but they do make firearms with what you refer to as an external safety, right?
Yes.
Can you explain to the jury just briefly how those work and the purpose of those?
Sure. An external safety is typically a button, a knob, something that you physically have to engage to prevent the firearm from firing.
And where is that? Where are those typically located on the firearm?
More times than not, you'll find them right back here on either the left or the right side. But those are typically referred to as thumb safeties, as all you need is your thumb to disengage it or engage it.
That firearm does not have any type of external safety?
No.
All right. With the firearm in the condition that it is right now, unloaded, are you able to demonstrate for the jury how to pull the trigger and to make that sound?
Yes.
Your Honor, may she do that? May she demonstrate pointing it into the wall?
Yes. I'll use my left just so you can see. One more.
And that's all someone would need to do to fire a shot if it was fully loaded?
Yes.
Thank you, ma'am. Judge, that's all I have.
Thank you. Any redirect?
Very brief on that one point. This gun safety mechanism requires that same amount of pull for every time you want to shoot the gun, correct?
Yes.
You agree that there are other semi-automatic weapons, a number of them, where while the first shot may be a double action pull, the ones after that are single action, correct?
Yes, there are some firearms designed that way.
And Sig Sauers are all that way, Colts are all that way, right?
Some of them, yes.
Okay. And what that means is while you can rack it and shoot with a 4.5, 5-pound pull or distance, every other one is featherweight, right?
A single pound trigger pull is going to be lighter than a double action trigger pull, but when you have a firearm that's both single action, double action, pulling back on the slide and releasing while you chamber a cartridge will leave the pistol in single action. So firing it that way will be the single action trigger pull, which will be lighter than a double. However, a lot of these firearms also have what's called a decock safety, which is essentially another thumb safety where you depress it and it will allow the hammer to fall without causing the gun to fire. And then by pulling the trigger at that stage, it's going to be a double action trigger pull, while all remaining ones, if you do not decock, are going to be at the single action trigger pull, which is lighter.
So with this gun, if I wanted to shoot it one time, 4.5-inch pull, correct?
4.5 to
Pound.
4 3/4 pounds, yes.
Sorry, 4 3/4 pound pull, correct? And then
Yes.
the second shot, again, 4 3/4 pound pull, correct?
Yes.
If I had my Sig Sauer 9mm with me and I did the same thing, first one, let's say 4.5 pound, correct?
I'm
And-
sorry, I'm just
and-
going to take this to the relevance of a different firearm.
Well,
Sustain.
any other firearm that goes from double to single, I think you probably could.
The objection was sustained.
But I'm moving on to the next question.
But we're still talking on firearms other than this firearm.
Well, she has now identified, if I might be heard,
I know, but the objection is relevance. That objection is sustained.
then this firearm's additional safety measures is that each pull has to be the full pull, correct? As opposed to shifting to single action after the first pull.
That's a design feature of a pistol that's either only single action or only double action, where
Which-
it has the same trigger pull for each shot.
Which means that even the second, third, and fourth shot require a full 4.5 to 4 3/4 pound pull.
Yes, each pull of the trigger requires the same amount of force.
And that is different than it would be if it was a single action, correct?
Yes.
Thank you. Nothing further on.
Any redirect?
No, thank you.
May Ms. Sieward be excused?
She may.
Thank you very much. You are excused. Deputy, so please put the lock back on the firearm and put it in the box. Ladies and gentlemen, we're going to go ahead and break for lunch. During lunch, you're not to discuss the case amongst yourselves or with anybody else. You're not to read or listen to any radio, television, or newspaper reports about the case. You're not to use any type of an electronic device to go on the internet to do independent research about the case, people, places, things, or terminology. And you're not to read or create any emails, text messages, Twitters, tweets, blogs, or social networking pages about the case. Do I have your assurances that you will abide by these instructions? Okay, there's something different going for lunch today, so I'm going to give you some extra time. If we will be back at 1:45. Please put your notepads face down on the chairs and enjoy your lunch. Did you put the lock? Is there anything, please be seated. Is there anything else that we need to take up before we recess for lunch? Okay, court will be in recess till 1:45.